Okay, everybody, I think we're on. So let's go to the slideshow. And the judiciary posted. It's in Unit 2, okay, in the branches of government. This is the third branch. As we say, one of the three branches of the government. And I'm going to ask you which article of the Constitution sets up the judicial branch. And I'm not going to tell you here. You should know that by now. You know that the judiciary, executive, and now the judicial branch. So it's up to you. Now, the Supreme Court is at the top of that pyramid. It is the last court of appeal. It's an appellate court, appellate meaning appeal, and cases are appealed all the way up through the U.S. Supreme Court. The Supreme Court does not have to hear them. If it does, whatever rule it makes, that's it. That's the end of that case. If it decides not to, through a writ of certiorari, and you'll see that in your reading, if they decide not to hear it, and they don't have to hear every case appealed to them, then the U.S. Court of Appeals, district courts, whatever lower court, a state Supreme Court, any of those, whatever decision was made at that level, then stands. Okay, but the Supreme Court does not have to hear every case. Now, origins of American law. This is really why we're here. Talk about common law, body of law developed from judicial decisions, okay, in English and U.S. courts, starting obviously in England, where we're descended from. These decisions, or these laws, are not from the legislature. Are they responsible to the legislature? The courts were not responsible to the legislature. They were the king's courts. The king established these. They had a parliament. But aside from the executive's ruling in the smaller areas, they just had courts that made decisions in cases, and those decisions became law, became common law. Okay, so they looked to the courts for their direction. And these decisions then, in these courts, applied throughout the entire country because they were the king's courts. Now, these are called precedents. A precedent, simply something you do now that sets the standard for a later decision or action. Now, in a court case, if it's a decision in a court, years later there may be a similar, or it may be exactly the same in a case, and the court will look back and see what the previous court decided and take that into consideration. Just into consideration. It doesn't mean they have to do it, because there may be other facts related, but they do consider that. Now, it's simply an example, as it says here, for deciding subsequent cases, but it doesn't mandate that a court use that. Okay. Now, let's go to stare decisis or stare decisis, depending on your Latin. Common law doctrine. All right, common law, because it's dealing with precedents. That's what stare decisis is. Now, under this doctrine, judges are obligated to follow the precedents. Okay, so if you believe in this doctrine, then while you can't mandate, certainly you believe the judges are obligated to follow the precedents. They may depart. That's an important thing. They may depart from the rule of precedent if they decide the rule is incorrect or inapplicable. Okay, and that has happened. Supreme Courts will overturn previous Supreme Court decisions. Let's go to Brown versus Board of Education. Overturned the decision overturned in Plessy versus Ferguson. Brown versus Board of Education said separate but equal facilities are constitutional. Plessy said no, they're not, and overturned the decision. Citizens United reversed the decision in McConnell. It had to do with campaigns and campaign finance reform, which was attempted in the McConnell case, and Citizens United reversed that 8 years later. And then, of course, Dred Scott v. Sanford. The reason we bring it up here is it's an example of a case that would have been, or a decision that would have been overturned, but the legislatures, actually the federal, our state legislatures, through the amendment process, actually amended the Constitution. And so the decision in Dred Scott was basically made moot because the Constitution was amended. So now the case itself, or the concern of the case, was no longer unconstitutional. I'm not going to ask about those guys. I am going to want you to know, too, does this principle currently affect appointment and approval of justices? Absolutely. Senators in the Senate, the Senate approves. So senators on the Judicial Committee are going to ask whoever is up to be a justice if they will follow stare decisis, because they all have cases that they want upheld, decisions they want upheld. So it is